Well, thank you, Midge. Thank you so much. It's wonderful to be here, and I thank the Rendell Center for getting us all together. It's a special treat that Justice Kennedy is here, and we're very, very grateful for you. Steve and I, it's wonderful to be on this podium with Steve Burbank. We've co-taught for a number of years, and he's one of the people that I most admire, and we've been long, long friends. So in thinking about this program, we thought we should try to frame and conduct our discussion so that it could contribute to overarching themes and goals of the symposium, especially how does the way in which judges decide cases relate to and affect the fair and impartial decision-making by the courts. Steve?
Well, first of all, I want to add my thanks to the judges, to Judge Rendell and Amy Gutman and others for this wonderful symposium. Welcome, Justice Kennedy. And also express my great pleasure in the opportunity to continue conversations with Tony. We've been having conversations as co-teachers for many years, although not directly about this subject. I encourage my first-year students and my students in general to be sure that they understand the premise or premises of a question before they answer it. And the question posed to Tony and me, which is how do judges decide cases, appears to reflect a premise that is faulty in ways that I think are illuminating given the goals of this symposium. At least if one is describing the work of the federal judiciary, judges do not decide cases. Courts decide cases. And I don't think that this is just a matter of semantics. Article 3 of the Constitution, as all of you know, vests judicial power. But it vests judicial power not in judges, but in courts. And that's a fact, I think, that should remind even judges who sit alone, as do the judges on the district courts, that they are part of an institution, one that existed before they joined it, and one that will continue to exist after they leave. And that their actions will be perceived by the public to reflect not just on themselves, but on the larger institution. It should also remind judges that their judicial independence exists primarily for the benefit of the institution's independence as a whole, and that their individual independence must occasionally yield so that the institution can be properly accountable. Of course, the federal courts of appeals and the Supreme Court do not sit alone, and that means that rather than deciding cases, they contribute. The judges on those courts don't sit alone, and that means that rather than deciding cases, they contribute to decisions of the group as a whole. Studies in law and political science demonstrate that such decisions are often more than the sum of their parts, meaning that judges on plural courts, the courts of appeals and the Supreme Court, affect and are affected by their colleagues when making decisions.
Well, I very much agree with those statements. Judges recognize that we serve as stewards of an institution that is absolutely essential to our democratic form of government. And we recognize that the force of reasoning and the integrity of the judicial process is essential to preserve the public's trust in the judiciary.
Tony, you've served as a trial court judge, as an appellate judge. You're deeply versed in the jurisprudence and culture of the Supreme Court. Even if we substitute courts for judges, are we at risk of indulging another faulty premise?
Well, I suppose if we accept the notion that different courts decide cases in the same way all the time, or indeed that the same court decides all of its cases in the same way, we are. But as you once said, rather than talking about judicial behavior, we should be talking about judicial behaviors, plural. There are a number of constraints that we face as appellate judges. First, our place in the judicial system influences the kind of restraints that we have. Obviously, there are differences between the trial court and the Court of Appeals. We always look, as appellate judges, at the case record on appeal. We look at the applicable law, and we look at the applicable precedents. Both the trial and the appellate courts are constrained by precedent of the higher courts or by circuit precedent as well. I think even the Supreme Court accords significance to precedent, although it is not irrevocably bound by that. Stare decisis implicates not just even-handedness and predictability that are certainly core rule of law values, but institutional legitimacy as well. Justice Cardozo once said that precedents fix the point of departure from which the labor of a judge begins. Judge Friendly called precedents accumulated wisdom. In the Third Circuit, we take precedents pretty seriously, not that other courts don't. Before we published an opinion and make it precedential, we circulate the proposed opinion to our entire court, including the senior judges along with the active judges. This gives every member of our court the opportunity to comment on it, to make suggestions, to make criticisms, and even, if they wish, to cast an initial en banc vote before the proposed opinion is ever made precedential. Of course, there's always, in many cases, a petition for rehearing, and we get to do it twice. So it's quite significant when we decide to make something precedential. The standards of review are also crucial and decide many cases on appeal, and many of these standards are deferential. Deference to the trial judge's fact-finding, deference to a jury verdict, deference to the trial court's decisions on discovery and evidentiary rulings, deference to agencies' fact-finding or statutory interpretations, either under Chevron standards, under a substantial evidence standard, or arbitrary and capricious review. So these are quite significant and must be taken into account. The courts of appeals are scrupulous in announcing the standard of review in the decisions that they render, so it's quite clear the basis on which we are making these decisions.
One of the problems with that branch of political science scholarship that Dean Levy referred to this morning, the so-called attitudinal school, is precisely the failure of many of those scholars to acknowledge differences among federal courts. We all know that lower federal courts lack the power of the Supreme Court to change the law. Tony's reference to standards of review is particularly apt in this context, because attitudinalists argue that those who champion the role of law in judicial decisions don't need to be or can be ignored unless they prove their case, namely to prove that law is causally responsible for decisions through acceptable methods. And of course, the only acceptable methods for these people are quantitative. Accepting that challenge, Professor Frank Cross actually did prove that law matters. And the way he proved it was by looking with sophisticated empirical methods at different standards of review, and he found that different standards of review actually make a difference. Tony, are the volume and mix of cases that a court decides relevant in thinking about how that court decides those cases?
It may very well be the case. Certainly there is random assignment in both the district courts and the courts of appeals. We know that the district courts, of course, cannot choose which or how many cases that they hear. And apart from the constraints that we've discussed, both their resources and the nature of their caseload can reduce the opportunities for any policy making. We know that the district courts on the border with Mexico are overwhelmed, and this kind of caseload can very much affect the way courts make decisions. Same is true, I guess, to a lesser extent with the Court of Appeals. We've had a flood of immigration appeals for the last 15 years, and it continues to go on.
Lesser extent may be an understatement, at least in those courts of appeals, and it's most of them, that decide most cases by non-presidential opinions, rely heavily on staff to draft them, and devote most of their attention to presidential opinions, the cumulative effect of which is to create a functional discretionary docket. But that said, even the Supreme Court, that of course does have a discretionary docket, decides a large proportion of their cases unanimously, as Judge Levy, sometimes Dean Levy, sometimes David, pointed out this morning. So in many cases, Justice Gorsuch and Justice Sotomayor are, in Tom Lehrer's immortal way of putting it, dancing cheek to cheek, which is an embarrassment for attitudinalists.
Steve, you mentioned unpublished opinions. We call them not precedential opinions in the Third Circuit, but they are the same. And I think just they're worth a comment here. These opinions are reasoned opinions that decide the merits of the appeals. They are publicly available, and nationwide consist of 80 to 90% of all the federal appellate decisions. They are not precedential, but they articulate the decision in the case. They may involve agency decisions. They may involve cases based on state rather than on federal law. They may involve sentencing appeals. They occur in cases where the law is clear and we can straightforwardly apply the law to the facts. Many times these cases are decided by our standard of review. And it's certainly true, at least on our court, that most of the time we spend goes to precedential opinions that can be very difficult and can take time. But that does not mean that we're neglecting our job on the not precedential opinions. They are assigned to all of the judges during our sittings, and each judge has a responsibility for drafting the opinion, and of course it is reviewed by the other two judges, often changed, and if we ever have a dissenting opinion in a not precedential opinion, which is quite rare, we circulate it to the full court before it is filed so that the full court gets a chance to look at that as well.
Your reference to docket pressures suggests that, at least with respect to the trial courts, the problem may not be, as some scholars recently observed, the problem may not be judicial activism, but rather judicial accuracy. These scholars, who tend to approach the study of law from the perspective of psychology, argue that judges are intuitive And they observe that intuition is generally less reliable than deliberation. And they feel that too many district courts are under so much pressure that too much of their decision-making is intuitive rather than deliberative, and make a number of proposals to alleviate that problem in the trial courts, including more resources, more judgeships, more opinions, which require deliberation, and increasing opportunities for education and feedback.
Well, I'm not sure that I'm in a position to be able to comment on whether judges are predominantly intuitive. We all are intuitive to a greater or lesser degree. And reading the facts of an appellate brief, I suppose, strikes our intuitive nerve. We have a sense as to whether the person has been treated fairly or equitably. Sometimes that does not decide the case. The law may decide otherwise. I think, in my experience in reviewing district court decisions, I just don't see it, or I certainly don't recognize it as such. District judges do a terrific job in applying the law when they are making multiple decisions every day. And the cases that we reverse in the district court are almost never because a poor job was done or something had been neglected. With respect to the federal courts, to the extent that there are intuitive inclinations, the genius of the panel is that there are deliberations that would check that, just as there is appellate review of district court decisions should that be a problem.
Yeah, I think they were talking only about trial courts. If we think sparing the presence of a certain justice of the Supreme Court of some recent pleading decisions, which require a district court, after purging a complaint of conclusory allegations, to decide whether the remaining factual allegations present a plausible claim of relief, that's a challenging task in the absence of a factual record. And it requires, I would suggest, that the judge assess plausibility on the basis of what the court called judicial experience and common sense. And it's not clear, to me at least, that district court judges, and this is not a criticism of district court judges at all, have much experience, or that their common sense is reliable with respect to many of the situations that come before them, which I think implicates the makeup of the judiciary, something that I want to talk about with you a little bit later. We talked about law and judicial preferences on policy as if they were discrete, apart from one another, opposites maybe. Do you agree with that?
Well, this is one of the hardest questions that we face. And I think a lot depends on the nature of the case and the context. Justice Cardozo, Judge Harry Edwards, Judge Jeff Sutton, and many other excellent judges have talked about this and have written about it as well. If we confine ourselves to hard cases, they must invite the exercise of judicial discretion so that policy views may be intertwined with formal legal doctrine. At least to me, hard cases weaken certitude and prompt study and much thought. As Dean Levy said this morning, leeway should be allowed in these kinds of cases. There is a distinction between proper and improper exercise of discretion. There is a distinction between personal preference and guided discretion. In the appellate context, deliberation with appellate colleagues is such an important part of decision-making. All of us have had our minds changed in the conference with our colleagues after argument. All of us have had our minds changed from time to time by the lawyers who present the oral argument. Sometimes I go into cases and into argument where I'm pretty much in equipoise. The arguments on both sides are so close, but it's only after getting to work and hearing the views of my colleagues am I able to form an opinion. Often we exchange memos after argument and prolong the discussion for as long as it takes. I found that moving from the trial court to the Court of Appeals provided me with a measure of reassurance in getting the views of my colleagues, and most especially in getting their critical comments that always informed and made better the opinions that I had.
Yeah, Dean Levy again spoke to this morning. We would not be well served, I think, if we had a system of law that was wholly determinate. My former colleague, Kim Shepley, wrote a wonderful essay in a book of essays on judicial independence in an interdisciplinary context about the Soviet-style legal systems, which were relentlessly formal and left no room for any discretion. Law needs discretion just as discretion needs law. One without the other is either weak or it's dangerous. A colleague at Berkeley and I recently completed a study of decisions of the courts of appeals on issues of class certification. We created a database that has every presidential court of appeals decision on issues of class certification from the time when Rule 23 was amended in 1966 through 2017, so it's a lot of cases. And we did this for a number of purposes. The first paper to come out of this work is a study of judicial behavior on the courts of appeals. And we found that not only does ideology play a major role in these decisions, even though they're procedure, but also that gender and race of the judges play a role, not just in terms of the vote of the particular judge, but in terms of the effect of that judge's participation on her colleagues. So my question for you, Tony, in your experience, and putting ideology to the side, do the identity characteristics of your colleagues on the bench affect, in your view, their policy preferences? And at the appellate level, do identity-driven preferences affect the votes of other members of the court in some types of cases?
I think I would take issue with the term identity preferences. Of course, our life experiences are important. Our parenting, our parents, and our parenting of our children, our upbringing, our education, our prior work experience, personal relationships, and all the life experiences that we can imagine. They're all important, but they don't involve the rule of law, and that's what our job is. A few years ago, I was at a Devitt Award ceremony for Ralph Winter, and who was the former chief judge of the Second Circuit, who many of you may know. And one of the speakers was John Newman, also a former chief judge of the Second Circuit and an old friend. And Judge Newman said, that he was delighted to speak on behalf of his good friend Ralph Winter. And he wanted to tell a particular story, and that story was they had been colleagues for 35 years, and only once in all that time had they ever dissented from one or the other's opinion. Pretty extraordinary. And he said there are two reasons. One, the first was perhaps we were persuaded by the other, and he said that's not the case. And he said if you know Ralph Winter, you know that could not be the case. He said the reason was because we saw the law in the same way, even though we did not like it in all cases. And he said we came to the court in different ways. He said our political views were different. We felt differently in terms of legal philosophies. We got here, he said, on a partisan basis. We know where we came from, but we recognized that when we went on the court, we had a new role, and that was the judicial role, and that has been our guiding light.
Well, of course, nobody who is, I got any sense, who writes about judicial behavior believes that there is for instance, a woman's view or a men's view or a racial minority view. But it has been established that in some types of cases, there are systematic differences in the preferences of men, women, and African Americans. Gender and race may be thought to matter for a number of different reasons. In Hannah Pitkin's famous typology, they may be thought to matter in terms of descriptive representation. If we think that the legitimacy of our courts depends to any extent on the way in which they mirror or don't mirror society, but also in terms of substantive representation, when preferences do systematically differ among different types of judges, are they able to have influence in implementing those preferences? And I would simply note that contrary to a trend that has been going on for decades, a trend towards diversifying the federal bench, if one looks at the judicial appointments over the last 3 years, one finds that they are overwhelmingly white and overwhelmingly male. The last time I looked, an African American had not been put on the Court of Appeals by President Trump.
Well, Steve, I didn't finish a full answer to your prior question, and I'd like to do that. Diversity is absolutely important on the bench. People with different life experiences are able to express views in a way that may not be understood immediately by others who have not had those experiences. And the more diversity, the better. And I've seen it in any number of ways. It's part of our deliberative process, and we educate one another either through the force of logic or through our experiences that we've had in the law as lawyers and also as judges in many different kinds of cases.
We've been talking mostly about differences between or among the various courts, and obviously focusing on the federal courts. Are there some constants that bear on the question whether the courts are fair and impartial?
Of course, and with a few exceptions, all of our courts are always open to the public and to the press. All of the decisions are available for public scrutiny and criticism. In addition, focusing on the lower federal courts, all lower federal court judges are subject to statutory or other requirements governing their conduct. The Supreme Court is not statutorily bound, but considers itself bound by the judiciary's code of conduct. All of us in the federal judiciary have from time to time traveled to other countries. We know how the rule of law is applied around the world in inconsistent manners. And we never come back to the United States without realizing and recognizing that our system, and that perhaps of a few other countries, is really a beacon for the world. And this is something that we should never forget. And it's something that we should build on. We're all involved in this extraordinary experiment in democracy, and it's wonderful as lawyers and judges and academics to be able to play a part.
We would now be happy to entertain some questions. We have about 10 minutes for that purpose, and cards are not necessary. There are some mics, but maybe if you have a question, you could just raise your voice. So are there any questions?
For the recording, the mics.
Okay.
Please come to the mic if you have a question.
Ah, great.
You won't get up here back there if you know.
It's for Judge Scirica. Tony, could you comment on the extent to which the experience you had in the state legislature has informed your work, both in the trial court and in the appellate court, if at all?
Quite a bit. It was an incredible learning experience, and with all of the good and maybe sometimes the not so good. I learned that statutes were rarely perfectly drafted. But I learned that there was a purpose behind each piece of proposed legislation, and that most members of the legislature maybe did not delve into the technical parts of the legislation, but they understood the principle, and they liked the principle, and they understood the remedy, and they liked the remedy, and so they cast a vote in favor. They recognized as well, and this happened many, many times, I heard from colleagues, we know that what we're doing is not exactly what we had hoped, but we expect and hope that the judiciary will act in a sensitive way. And in fact, more than that, there was an expectation that the judiciary would be sensible in interpretation. Other than that, it gave you a feeling for the structure of governments, local, state, and federal, the interaction, the issues. When I always think of this when we have preemption issues as to where courts and lawyers ought to be on certain kinds of cases. But more than that, it was composed of farmers, of steelworkers, community activists, teachers, every kind of occupation you can think of, and many, many good lawyers. The other thing was that it was a part-time job at that time, which was many years ago, so you could have a law practice, and so you had a foot in both houses. So yes, it was a very valuable experience.
It was also a very valuable experience for Judge Scirica in terms of the work, some of the work that he's done. He's done so much work for the judiciary as a whole. Judge Scirica has been key at various points in negotiating with members of Congress over proposed legislation. And he reminds me very much of the late, great Richard Arnold, who was chair of the Budget Committee because of his political experience. And he said, Judge Arnold said that he enjoyed his service as chair of the Budget Committee because it has a little touch of politics about it, and I have always enjoyed politics. He also observed that politics is people, and it should be and can be an honorable profession. And of course, Judge Scirica exemplifies that.
Could you speak more about or revisit stare decisis, its relationship to perception of a fair and impartial judiciary, and the choices judges make when they choose to reject stare decisis and move in a different direction?
Well, I think you may be talking to the wrong court here.
That's what I could find.
I hope that I hope that I have not rejected stare decisis. Obviously, at the Court of Appeals level, we get, just as the district judges get, new cases. There's no controlling precedent in the area of, well, standing seems to come and go as an important issue, obviously, in many kinds of cases involving injury to privacy. There's always an important standing issue. So in that area, we've been striking out a bit. Supreme Court has dealt with that issue, and I suspect we'll be dealing with it a lot more. You do the best you can. I believe very much what Judge Friendly said, that precedent is accumulated wisdom. It may not decide the case for you, but it gets you on the way. And it's important to see how other courts have grappled with similar issues. Writing narrowly is often a way to deal with new issues and old issues as well. Paradoxically, it may create more latitude, maybe not paradoxically, more latitude, because you're just deciding the issues in front of you. You're not going beyond that. And it may bring other members of the panel to a consensus because they're not uncomfortable with going beyond just the narrow holding. So I found that to be quite helpful in dealing with new matters as well.
But in terms of the issues of this symposium, it seems to me that stare decisis, even on the Supreme Court, which is not bound to follow precedent, but most of the justices, most of the time, reflect an understanding that stare decisis is important for litigants in terms of the perception of equal treatment and for predictability, which are core rule of law values that everybody recognizes are tremendously important to the development and maintenance of a well-functioning economy, for instance, which is why so many other countries emerging from authoritarian rules look to the judges from this country to educate them. But of course, it's also important for the perception of legitimacy. And Richard Arnold, I'll call upon again, used to talk about the fact that the judiciary required the consent of the governed. And what he was referring to is what political scientists refer to as diffuse support, as opposed to specific support for this or that decision. Support of the sort that is reflected in some of the surveys that we heard this morning. The Supreme Court and all of the federal courts require the public's support. And if they have the public support, they will better be able to defend themselves from the depredations of the other branches of government. If they lose that support, as I think Professor Jay was suggesting also this morning, we're in very serious trouble. So stare decisis is tremendously important for litigants, and it's tremendously important for the institution itself.
Other questions?
I think we used up our time. We got one more.
Any thought about the constant proposals about inspector generals for the judiciary and its possible effect on independence?
I think I wrote a law review article on this a few years ago.
I thought that was my line.
Steve has written several books. I just wrote a law review article. I think it would be a huge mistake. The self-governance of the judiciary is absolutely key, and not just decisional, to guarantee decisional independence, but institutional independence as well.
And I think you're talking here about the role of accountability, which is key to judicial independence.
Absolutely, and Steve has written about this for years. He's called it the other side of judicial independence, and it very much is. And of course it means that we have to be accountable in many ways, not just institutionally, but also in terms of the integrity of the legal process, the avoidance of conflicts of interests, and from time to time, other kinds of conduct. It struck me in working on this article that there was something else that occurred to me that I hadn't read. And maybe it was because I had been a chief judge for 7 years and had to deal with the transgressions of various kinds under the Conduct and Disability Statute, or disability problems, particularly dealing with other judges and older judges as well. If this responsibility were given to another branch of government, even if it were given to an inspector general who was appointed by the Chief Justice, for example, and some of the statutes that were proposed did that, it would take away from the judiciary the responsibility of making sure its house was in order all the time. The judges that have to deal with these issues, and most of them are district court judges, chief district court judges, even before the chief circuit judge hears about the problem. It would take away this responsibility that we have to do things in the right way in all different spheres. And I think it would change the character of the federal judiciary. And so when I talk to Congress about these matters, I've tried to impress this upon them, but we'll see what happens. Good.